I'm just going to do a quick explanation about the personal injury claims process, just to give you an insight into how the process would normally take place. If you have been the unfortunate victim of an accident that's caused you any injury, you have the right to bring a claim if that accident arose as a result of somebody else's negligence or somebody else's fault. When you bring such a claim, it's always a good idea to try and get the evidence and the information that you need at an early stage to prove your claim. That starts at the time the accident happens, and it's really for you as the claimant to make sure you've got as much information available which will help prove the claim from the start. If you have the opportunity of taking some photographs, getting details of witnesses, speaking to other people at the scene, it helps when you give instructions to a solicitor, because it then narrows down the issues between yourself and the insurers in due course. Where there is an injury, you're obviously going to need to be seen by a doctor. It's a very good idea when you go and see the doctor, whether it's a hospital or your GP, to make sure that that doctor is fully appraised of all the injuries and symptoms that you're suffering. Sometimes insurers at a later stage in the claim may try and argue that some of the heads of injury that you're pursuing were not actually injuries arising from the accident. So if you've got fully documented medical records, it will help to narrow down those sort of issues as and when the claim process gets towards the settlement stage. Once you've got the details of the claim, once you've seen your doctor, then you ought to go and speak to a solicitor. The solicitor should take full and detailed instructions from you about all the circumstances of the accident, about your injuries, about any other issues which may be connected to the valuing of the claim, so that your claim process can then start in earnest. The way the claim system works at present depends on whether you're running a road traffic accident, a work accident, public liability accident, or the like. With a road accident at the moment, there is something called the Ministry of Justice process, where the claim is actually intimated through an electronic service and not formally by a letter of claim. That will also apply shortly, by the end of July, to work accidents and public liability claims. In that circumstance, the initial claim is intimated using what we call a claims notification form, or a CNF form. It's quite a detailed form, and it therefore does require quite a lot of information to be given to your solicitor right at the outset. It does, however, speed up the process slightly, because you are giving much more information from the start. If it's not proceeding through that system, then the solicitor will actually intimate the claim using a formal letter of claim that they prepare for you. And it will contain roughly similar information, but perhaps not just quite as much detail. In either case, the other side, whether it be the defendant or their insurers, then have to respond. Where there's no response, the claim will have to proceed to potentially issuing proceedings at an earlier stage. But in most cases, the insurers or the defendant will reply fairly quickly, and the investigation process for the claim will get underway. Most claims, if you've got the evidence and you've established liability early on, will follow from the letter of claim with an admission of liability, or at least an admission of partial liability. At that stage, it will be time for you to look towards getting a medical report so that you can establish the full extent of injury. Depending on the severity of your injuries, that may be one initial report, or it may be a report from a number of experts, such as an orthopaedic report, a psychological report, and the like. When your medical evidence is complete, at that stage the reports can be served on the other side, and hopefully discussions can start to take place with regard to settlement. Your solicitor, in the meantime, should have been gathering information with regard to any financial losses, whether that be loss of earnings, whether it be damage to your vehicle, any other items of loss, clothing or otherwise that may have been damaged in the accident. And so at the time when settlement can start to take place, a full schedule of loss as well as the medical reports can be disclosed to the other party. Your solicitor should also be explaining to you throughout the claims process what the likely potential heads of claim are going to be, so that you can be helping putting that information together and making sure that you can get the most out of your claim that is available to you. You only have one opportunity to run that claim, and therefore you need to make sure it is done properly from the outset. Where there's a dispute on liability, or if there's a dispute that's purely and simply with regard to the value of the claim, if the parties can't agree terms of settlement, then the ultimate arbitrator has got to be the court. In that circumstance, your solicitor will have to prepare and issue court proceedings on your behalf. Most cases where proceedings are issued do not actually get to trial. There's probably only about 2% of cases that ever get to a trial hearing. Most of them will settle either at the 11th hour before the trial or at some stage from the commencement of the proceedings through to the actual trial hearing. It can be quite a daunting experience going to a court, and that does put a lot of claimants on edge. But if you've got a solicitor who's fully explaining the process to you and explaining the risks, it shouldn't be a matter that should cause you undue concern. If your solicitor is running that case and is confident that you are able to win it, and you have sufficient evidence to go forward, then you should trust in your solicitor and take the matter forward with that solicitor's advice. Hopefully at some stage negotiations for settlement will take place, or you'll get into a hearing where the judge will be looking at the value of the claim. The way the claim is valued is dependent upon what is contained in your medical reports and what actual financial losses you've incurred. Your solicitor should have advised you, and potentially even a barrister had given you some advice as to the likely value of the claim. And so hopefully when you get to that stage you can make an informed decision on whether any offer that is put forward should be accepted.